Joining me now on the show, the official Fox Sports 910 legal expert, Byron Browne of the Browne Law Group, Big B, the anti-lawyer lawyer, joining us here via the Sanderson Ford hotline. Big B, listen, we got a couple of interesting football topics to get to. Let's start with one that's obviously a very sad story, but I do think in terms of all the cases that you and I have discussed and tapped into your legal expertise, this may be the one that has some of the most translation to our listeners. And so Janoris Jenkins, defensive back of the New York Giants, he was in Florida. It was discovered that a home that he owns in New Jersey, a body was found on that property near death. That person has subsequently passed away. He was not in state or in the home at the time. Turns out his brother is suspected of committing this violent act. But here's my question is, not that people come home from work every day or get a phone call saying that there's a body found by their pool or something, but like what does happen? Like what do you go through if something happens on your property and you're not there? How much legal culpability did you have? How much was Janoris Jenkins sort of sweating out this case?
I don't know how much he would be. Just to give an analogy, if you're not at your home, saying someone's on your property and they slip and fall and they break their ankle, I think 9.9 times you're going to be liable for that broken ankle. Now, on the other end of the spectrum, we have here, which, is a homicide or manslaughter. Most homeowners' insurance policies, which would be what would kick in to provide coverage and payment for such a claim, there's most likely an exclusion within that policy that says, hey, if an intentional tort such as murder, manslaughter, an assault takes place, then there's going to be no insurance. Now, obviously, with a gentleman that plays in the NFL, he's got a lot of money, so I think the family in that situation would still go after him. I think his liability is very limited in that case because it's a roommate. Now, does Jenkins know about a history of violence between the two brothers, between only one of the brothers? It's going to be very fact-specific as it relates to his liability. Now, if he has a lot of knowledge that something like this was very likely to take place, then I think his liability is very high. On the flip, if he had very limited knowledge that this relationship was volatile and could lead to something like this, then his liability is going to be very limited, in my opinion.
So I want to go back to something you said at the initial part of that answer. If someone is just like, I'm at work right now, if a neighborhood kid climbs over my fence to retrieve a ball that got thrown over the fence, and while climbing over the fence on my property, they slip and injure themselves, I'm liable for that?
You could be, as ridiculous as it sounds, you could be liable. Now, again, it would be very fact-specific. Do you have knowledge that this boy kept climbing over your fence? There's a law called an attractive nuisance, and if you knew that his ball kept going over his fence and that the kid was going to continue to do it and you didn't do anything, say tell the parents, tell the kid to not do it, you could be. I think that is very, very unlikely, but right. I got to tell you, there's lawyers out there that would take that claim, try to make a claim against your homeowner's insurance policy, maybe take it as far as a lawsuit. Again, that example you give, I think, is very low, but if you just want to switch it and say, hey, you got a pool in your backyard and you know the neighborhood kid keeps coming over, then we have this application of an attractive nuisance where hey, I got a pool. Hey, I know the neighbor kid doesn't. Hey, I know it's really hot outside. I know the kid keeps coming in here. And you don't do anything to remedy that, like no trespassing, go and talk to the parents, do anything, and an accident happens where he injures himself, then I think that you would face some liability in that case. And again, when I say some, you don't always have to have a case that's a 10 out of 10 to make a claim. I mean, you could have a case that's like 5 out of 10 and hypothetically say your case is worth $100, but it's not the best case. Well, then that case might still be worth $50. And so that's why we hear some of these cases and you're like, man, is that really a claim? Well, Unfortunately, a lot of times it is. Even though I think that those are a drain on the legal system, they do happen.
It's interesting you say that because personally, we recently put up a swing and a tree in our front yard, and it's 2 ropes, and then the swing connects separately. And I told my wife, she thought I was being kind of paranoid, but I was like, we need to make sure that we take this swing down after every use with our daughter, because if we leave it up and a neighbor kid just decides to hop on the swing and a branch breaks or they fall over and bonk themselves, I felt like we would be responsible for that. And she thought I was being like paranoid and like thinking too much about it. But I feel like now I think you may have helped me win an argument.
I don't want to get on the backside of Miss Jody, but I think you got that one.
All right, let's talk about the collusion case in the NFL. Byron Browne, the official Fox Sports 910 legal expert, joining us here on The Drive. We've kept touch on this collusion case between Colin Kaepernick and the NFL as stories progressed, as new angles emerged. The latest on this story is that the NFL is attempting, according to this report, to force an end, essentially, to Colin Kaepernick's collusion case. They've requested that the arbitrator provide a summary judgment in the case. What does that mean to the layman as we read this?
Yeah, so a motion for summary judgment is a very typical vehicle to try to bring a case to a close. And so essentially what it is the NFL is asking the arbitrator to make a decision that there can be no successful cause of action or legal cause of action that can exist against the NFL in the Kaepernick case. Now, in doing that, what the rules state is that the arbitrator needs to look at all the issues before him in the most favorable light to Kaepernick. And so typically what we see in motion for summary judgment is they're very rarely successful. I can't imagine the NFL ever wins this motion. I think what the NFL's legal team is more likely doing with this motion is testing the waters. They're going to put all the issues before the judge, and then the judge is going to have to write an opinion. And the opinion, he'll say, hey, listen, I think, X and Y still needs to be brought out. And what he would mean by that is the discovery phase of a lawsuit, when we gather facts and evidence, he's going to say, hey, listen, you guys got to, bring out some testimony as it relates to issue X, and you got to bring out some documents as it relates to issue Y. And then, you know what, I'll have a better picture on whether to grant or to deny the motion. And so then he would deny the motion without prejudice. But the benefit to the NFL legal team is then they have kind of framed the issues in front of the arbitrator, at the same time gotten feedback from the arbitrator where they now know where the arbitrator may or may not be leaning. And now they can focus their discovery, fact-gathering efforts to then later bring that motion again, because it'll be denied without prejudice, which means the NFL's free to bring it essentially as many times as they want, as long as it keeps being denied without prejudice. So then at the close of discovery, when Kaepernick's legal team and the NFL can no longer gather any facts about the lawsuit, then they could refile that motion, bring it before that same arbitrator, obviously, and then say, hey, arbitrator, remember 8 months ago you told us you wanted X and Y fleshed out a bit more. Well, now we have, and these are in favor of us. So now you need to grant our motion for summary judgment.
So it's interesting because if I'm understanding it correctly, it's almost like the NFL. If this is a poker game between the NFL and Colin Kaepernick, the arbitrator essentially is going to clue the NFL in somewhat of what kind of hand Colin Kaepernick and his team have. Like, it's basically like an end around. Like, instead of walking over and being able to lift up Kaepernick's cards themselves, they get like a written summary to kind of describe what the hand, how strong it may or may not be.
Exactly. That's very well put.
That's crazy because what is Kaepernick's side? What are they able to do to sort of protect themselves if they feel like they've got a strong case but still need, still would like, I guess, to shield the NFL from it? In that case, it sounds like the NFL has all the leverage, even if they lose this summary.
No. I don't believe that at all.
Okay.
What Kaepernick's team's going to do is they're going to oppose it, and obviously they're kind of on their heels, because the NFL, whoever punches first gets to punch last. So the NFL files the initial motion. Kaepernick's legal team gets to file an opposition, and then the NFL gets to come in again pursuant to the rules and file a reply. So they kind of get two kicks of the can. So Kaepernick's team gets the same benefit that the NFL does, right?
Gotcha.
They'll probably file an opposition. They might also simultaneously file their own motion for summary judgment on certain legal issues, because you can file them on issues. You don't have to file them on the whole case. And then plus, Kaepernick's legal team will probably file off like with the opposition motion for attorney's fees and costs incurred in opposing it. And so then they get the same benefit as the NFL, because they're going to be able to get insight into what this arbitrator is leaning towards or not leaning towards. So I don't think Kaepernick's legal team is scared by this at all.
Gotcha.
Us as lawyers, this is as common as Sunday morning breakfast.
So, and last point about this, it feels like the NFL, it's going to be a big headline in the sports world that the NFL is requesting this summary judgment. It seems also likely that if the NFL loses this, it would be a big headline, but it doesn't necessarily reflect that either side is winning or losing. This is just sort of common practice in a case like this.
Yeah, 100%. Honestly, between the lawyers, it's nothing. I mean, if they win it, it'll be a big deal, but
right.
I don't see the NFL winning it at all. Yeah, amongst lawyers, I think any lawyer who practices within this field would be like, oh, yeah, like they're going to file we call them MSJs, motion for summary judgment. They'll file an op. We'll get the issues framed, and then the case moves forward.
So much paperwork being a lawyer, man. It's just one paperwork battle after another, isn't it?
Exactly.
All right, great stuff. Insight into the world of law and sports intersecting. Our own Byron Browne, the official Fox Sports 910 legal expert. Byron, always appreciate your expertise. Thanks for joining us, man.
Hey, thanks, Jody.